E ku iluna. Please rise. Auhea o ko e ko ka aha, inahe kuliana I mua kea aha o kolo kolo ki hano hano o ko moko aina o Hawaii. E nai mai, e malio mai, I lohi ia ka leo. Hear ye, hear ye, hear ye, all persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilalu. Please be seated.
All right, please call the case.
SCWC-20-0000286 in re Moloaa Farms LLC, Respondent Claimant Appellant versus Paul C. Huber individually, Petitioner and Respondent, Respondent Appellee, and Association of Apartment Owners of Moloaa Hui 1 and Paul C. Huber as its President, Association of Apartment Owners of Moloaa Hui 2, and Ned Y. Whitlock as its president, respondents and petitioners, respondents, appellees, and Candace L. Strong individually, respondent and petitioner, respondent appellee, and Moloaa Hui Lands Incorporated, and Eric M. Strong as its president and chief executive officer, respondents, respondent appellees. Arguing for AOAO of Moloaa Hui 1 and its president, Paul C. Huber, Matt A. Tukazaki, and also appearing, Michelle Chapman. Arguing for Paul C. Huber individually, Carl H. Osaki. Arguing for Candace L. Strong individually, Jason G. F. Wong. Also appearing is Michael A. Okazaki. And arguing for Moloaa Farms LLC, Timothy H. Irons. Argument on the merits.
All right. Good morning. Aloha, everyone. Today's proceedings being broadcast live on the Judiciary's YouTube channel, as well as on Olelo. Counsel, are you ready to proceed? Everyone? All right. We've allocated 30 minutes to each side, and we have a fairly complex distribution of time. I'll just summarize. Mr. Sukazaki, 11 minutes for your opening argument, 4 minutes for rebuttal. Mr. Osaki, 6 minutes for your opening, 2 minutes for rebuttal. Mr. Wong, 5 minutes with 2 minutes reserved for rebuttal. Mr. Irons, 30 minutes with a 5-minute warning when you're up at the end of your time. You may be seated, and please proceed.
Thank you, Mr. Chief Justice. Your Honors, may it please the Court. Nearly 5 years ago, in terminating an arbitration that the appellant was trying to force on 2 homeowners associations, Judge Kathleen Watanabe, Judge of the Fifth Circuit Court, ensured that her court and this court, or the appellate courts of Hawaii, would have a say in a case involving a controversy concerning appellant's demand for water rights from a public water resource that was being developed and operated by a cooperative formed by the 2 associations and a 3rd associations to support the farming community in the Moloaa farming district. In terminating the arbitration demand by the appellant, Judge Watanabe made a number of rulings relating to basically what's before you, an option agreement and the 1997 Declaration of Covenants, Conditions, and Restrictions that the developer filed. And as to those documents, she found there was no valid and enforceable arbitration agreement and that the issues in the demand for arbitration were not arbitrable. She also found that she had jurisdiction under Hawaii Waters Rights Law, HRS 664-32 and 33, in that the case before her was a controversy between private parties concerning water rights. On behalf of the 2 associations, appellees and petitioners, Association of Apartment Owners of Moloaa Hui 1 and 2, Ms. Michelle Chapman and I respectfully request that this court affirm Judge Watanabe's ruling. My name is Matt Sukazaki, and for the associations, I will be presenting the argument today. Unless the court has specific questions about the option agreement and about the 1997 declaration as not being valid and enforceable arbitration agreements, I want to jump right to what the ICA addressed, which was whether or not the issues in the demand were arbitrable. And specifically, yes,
I do have questions. In terms of the option agreement, it says what was being conveyed to the Lindner party was on page 2, subsection, the recitals G. It included not just the real property and all rights appurtenant to the property, including water rights. And so I'm wondering, what was the role of the tank with respect to what ends up being lot 2? Did the lot 2 need the water tank also?
my understanding, Judge, is that the water tank was there with respect to water being provided by under a lease that Moloaa Farms was operating. Right. The developer had contracted with Moloaa Farms to operate this pump and provide water to the facility. That's where the water came from. Right. The developer in the 1997 declaration made no promises and specifically said there's no guarantees that it was providing regarding water to anybody. But that's the source of the water at that time.
Well, okay, so then when MIC was created, what happened to the water tank?
The appellant still operated that water tank. They still had the facility and they still operated the water. They still had the lease with the state to operate that well to draw water from to support the project. So what happened was...
So, but after MIC, I'm not sure whether it's proceeded or not, but what is the intent? What was going to happen after MIC in terms of Hui 1 and Hui 2 and the water they would get? Would it use the tank? I thought they purchased that.
They purchased the tank. So the tank stored the water, but the water came from Moloaa Farms, and the water was pumped in the tank to support the facility. That's my understanding.
Which facility? Both Lot 2 and...
Not Lot 2. The understanding regarding Lot 2 is, and this is to make clear, Lot 2 was a separate deal from everything else.
Lot 2 never used the tank water.
Well, Lot 2 was a separate deal in the sense that when the developer created this project and specifically defined or described Lot 2, and that's when you look at the declaration about excluded lands, that was to take that they had to take care of themselves.
Okay, let's not talk about the declaration. I'm just talking about the option agreement right now. Okay? Right. And the facts. Was Lot 2 also using the tank water?
That I don't know, Your Honor, because Lot 2 is, as I understood it, has not yet been developed. So there's nothing for it to draw water from or for, in a sense. So the understanding from the declaration, whatever the developer at that time was trying to transfer to as the option, what you would buy, you would have whatever rights you would have to your land. You can do whatever you want with it. You would have whatever rights you have to that land that you were responsible.
As part of the option agreement, when the land was transferred in 1998, the land with the water well, it was unclear, the tank, it was unclear who owned it?
No, that was not the case. That was separate and apart from the creation of Lot 2. That had nothing to do with Lot 2. That's not on Lot 2's land.
Was it who owned the parcel with the tank on it?
From my understanding, is the developer. Okay. Moloaa Hui Farm, right. Land Inc. owned the tank. At least in the declaration, I have to go back to the declaration.
Declaration, MIC after MIC, would Lot 2 still be able to draw water out of that tank?
No. Lot 2...
So Lot 2 would not have any water rights?
No. My understanding is Lot 2 has, as we sit today, a separate water source that can support Lot 2 that Moloaa Farms, Inc. controls.
I see. So separate and apart from this tank parcel.
Correct.
So they have other sources.
Yes.
They have another source where they can store the water and use it.
Yes. Previously, they had the lease from the state to operate the well, that they had a contract with the developer to provide water to the rest of the developer's project, which is essentially the association lots.
And that lease expired.
And that lease is over. They returned back. They expired or they did not renew it. But they have a separate, as I sit here today, as I understand it, they have a separate water source from which they could use. Trying to access or making rights against the co-op's water source that they're developing is a separate deal, right? It's basically...
But doesn't the declaration treat that as a common element? And I'm looking at the declaration, I think it's section 1. And it seemed to be talking about the water systems and improvements there too as a common element. Is that a misreading?
If you're looking, just to make sure clear, in the 1997 declaration that the developer filed that expressed his intent of what he planned to do with the project, there is the paragraph I think you're referencing where it recognizes that it would treat the expenses equally to the parties that would use the water source. Okay, I think that's what the reference is to. It's not per se a common element as we understand a common element as defined under HRS 514B. It is just basically a recognition that they will treat it as a common expense. The other thing about this is
common obligations and expense.
Yes, common obligation and expense. It doesn't, there's nothing in that declaration that recognizes the water facility or the tank or anything like that as a common element.
Okay, but in the description of the project in that section that I'm referencing, Lot 2 was part of that project, right? That would have been inclusive at the time before the subdivision.
Lot 2 would be a part of it to the extent that Lot 2 is derived from what was defined as excluded lands. But when you look at that paragraph, it's in the section 1 that defines the project, paragraph 2. When they define excluded lands, there's certain representations there that make it clear that not all the provisions within the declaration applies to excluded lands. It expressly says it in there that other than the restriction regarding pesticides and herbicides, that you can't use it, that the excluded lands would not be used for farming purposes. They would have residential, recreational, or commercial uses. They would not be bound by the use restrictions in the declaration. And expressly it says that the excluded lands may or may not, the other covenants may or may not apply to the excluded lands. There is...
Can I switch gears a bit? I follow that argument. I appreciate that. I want to ask about the arbitrability because the option agreement seems to make clear that arbitration is going to be the way to resolve disputes, not litigation, and that it's going to be under the AAA rules. And the AAA rules seem to make real clear that arbitrability is reserved to the arbitrator. And I'm just wondering what's not clear about that.
The AAA rule R7, generally states that the arbitrator has the power to decide his or her jurisdiction. That's what it says.
Including arbitrability of any claim.
Yeah.
That's also part of the powers that were reserved to the arbitrator.
Yes. This court in Hawaii State Teachers Association versus University Lab School, okay, I believe it's 136 Hawaii
I'm familiar with the case.
That one, the court specifically said there needs to be a clear and unmistakable reservation. And in that,
the AAA rules has that reservation. I'm just wondering, should they have clipped that page out and stapled it to the back of the option agreement to make it clearer?
No, I don't necessarily agree that it is that clear. It is a general statement of what power it has. It does not say in the AAA rules that the AAA or the arbitrator has jurisdiction if there is the dispute as to arbitrability, that the arbitrator can decide this issue, or that if there's a question about who has jurisdiction, the court or the arbitrator the arbitrator can make that decision. It doesn't say that. Basically, in Hawaii State Teachers Association, it was very clear. Unmistakable, clear and unmistakable reservation of arbitrability. In that case, it specifically said that the arbitrator will make a decision or can make the first determination if there's a dispute as to arbitrability. That's what happened in this case. But if you also
I'm just not so sure it's unclear when I look at the AAA rules. I mean, many people use those rules and it's referenced in many arbitration agreements, and it seems to reserve arbitrability to the arbitrator. And I'm not seeing what's unclear about that.
if you look at both the option agreement provision and also the 1997 declaration, you have to start from the premise of what are the AAA rules being adopted for to be applied in that instance. In the 1997 declaration, the phrase basically starts, unless the party agree otherwise, the commercial rules of the American Arbitration Association, then in effect, shall govern the course of the arbitration. There's two parts to that. The first part of it is, unless the parties agree otherwise. That phrase contemplates a discussion by the parties who are contemplating arbitration. Either they negotiate it or at least they discuss it, and they can decide at that point, do they want the AAA rules to apply? Do they want some of the rules to apply? Or basically, in this particular instance, are they going to adopt Rule R7?
The option agreement says it shall apply.
Understood. But at that moment, for the same instance, part of that is at the point of having an existing arbitration. That's what the reference is. You have an arbitration and we'll apply these rules. We were at the stage of, are we going to have an arbitration or not? The appellant said, I'm demanding arbitration. All the respondents said, no, we don't agree that there is arbitration. So there is nothing at that point in time to apply the AAA rules. Discovery, motion practice, continuances, all those rules that govern the course of an arbitration.
Mr. Suksaki, you're well over your time, but is there anything else you want to mention now, or you want to have some, I will give you some extra time for rebuttal.
I can save it. I want to make one last point
Okay.
on the basically the arbitrability issue. There's two aspects of when you look at the language. This court has basically made clear that when you interpret these documents, you use the plain and ordinary language of the document to interpret its intent. When you look at Hawaii State Teachers Associations, it was very clear. Clear and unmistakable reservation of arbitrability. If there's any doubt in any of that, the circuit court retains the jurisdiction under 514D, under HRS 658A-6 and 7 to decide whether or not the issues are arbitrable or not. Thank you.
Very well, thank you. Mr. Osaki.
Good morning.
Morning.
May it please the court. My name is Carl Osaki. I represent Paul Huber as an individual in this case. As to Mr. Huber individually, the issue before us is what is the scope of what Mr. Huber back in February of 1997, what did he agree to arbitrate? And the determination of that, in turn, also defines the longevity of the arbitration agreement itself. And it would not apply to a dispute that arose in 2018 at the earliest. So when you look at the bargain sale option agreement, Mr. Huber signed it as an individual, as a contingency. He signed it contingent upon at least two other contingencies. And those contingencies are, number one, that Moloaa would be able to buy the property from Lihue Plantation. Number two, that best efforts to either subdivide or condominiumize that purchase would result in the creation of Lot 2. Third contingency is the option itself, whether Mr. Lindner would then exercise his option to buy Lot 2, thereby converting his funding of $500,000 toward the purchase from Lihui Plantation toward the purchase price, or whether Mr. Lindner would not exercise the option, in which case that funding of $500,000 would remain a loan. And in that case, three contingencies later, Mr. Huber agreed to be responsible for that repayment of that loan, along with Mr. and Mrs. Strong. So that's what he agreed to do under the option. The option arbitration clause says the parties agree to arbitrate disputes arising hereunder, not the parties agree to arbitrate any and all claims whenever arising, wherever arising, whatever it involves.
Why would hereunder end at the land purchase and not the water rights pertinent to that land?
Okay. Because in Mr. Huber's case, as an individual, right, his obligations under that option were never implicated, ever, because Mr. Lindner actually exercised his option to purchase Lot 2. Once Mr. Lindner exercised that option to purchase, Mr. Huber's involvement was done. He's not involved. There's no dispute that could arise under the option that would involve Mr. Huber individually. So once, I think it was in August of 1998, once Mr. Lindner exercised the option, said, I want to purchase Lot 2, I want the funding of $500,000 to go toward the purchase price, Mr. Huber's signature on that option as the potential debtor of that loan that never existed, completely finished.
Why isn't this a matter for the arbitrator to determine, in your view?
Because I think, as Mr. Tsukazaki pointed out, the parties within the contract itself, within the option, did not clearly and unambiguously reserve that question to the arbitrator. And in this Hawaii State Teachers, there's no question that the parties did that, because I think there's language in there that says if the employer disputes the arbitrability of any grievance submitted to arbitration, the arbitrator shall first determine the question of arbitrability. Now, that's clear, and that's unmistakable. That's an unmistakable reservation to the arbitrator, which is not present in this case.
Is the declaration at all relevant to our assessment of what your client's rights and interests in this matter are?
No. Mr. Huber did not sign the declaration. And I think it's pretty much Hornbook law that you have to be able to show someone agreed to arbitrate, and then you have to be able to show what that person agreed to arbitrate on. So a water rights dispute arising 20 years later? No. Mr. Huber individually never agreed to that. In fact, what he agreed to arbitrate never occurred, because the contingency for that never happened.
Very well, anything further for the court? Just about in your 6 minutes. So
I think that's about it.
all right. Very well. Thank you, Mr. Osaki.
Thank you.
All right. Mr. Wong.
Good morning, everyone. My name is Jason Wong. I am the attorney for petitioner Candace Strong. Michael Okazaki is also here representing petitioner Candace Strong, but I will be doing the arguments. I only have a very few minutes, so I'll try and keep this very brief. The key issues for my client is whether or not there was an agreement between my client, Candace Strong, to arbitrate, and whether or not she knowingly and clearly waived her right to a jury trial. If those two issues are not found in the affirmative, the question of arbitrability does not even arise. And that's what happens here, Judge. I'm sorry?
No.
Oh, sorry.
No. Sorry.
Under Lee versus SIDA, for there to be a waiver of a right to a jury trial, there has to be a showing of unequivocal and clear showing of a waiver. And every reasonable presumption is against that waiver. If you go to the case of Luke v. Gentry, 105 Hawaii 241, the contract has to be read as a whole, not just using one word.
Okay, so if you read the contract as a whole, you are agreeing to an arbitration agreement, notwithstanding some of the arguments that have been made. And if you agree to the arbitration rules, aren't you inherently waiving your right to a jury trial?
I think the threshold question is whether or not we agreed to arbitrate. Ms. Strong agreed to arbitrate. If there's no agreement to arbitrate, the rules are inapplicable.
I understand that, but you were raising the prospect of Ms. Strong not waiving her right to a jury trial. And if we believe that the rules of arbitration do apply pursuant to the various docs, the option, the declaration, does that pretty much eliminate your jury trial issue? Or is there something more that needs to be in there besides Rule 7?
I think I believe if she did not waive if she waived the right to a jury trial and there was an agreement to arbitrate, then it seems clear that Rule 7 would apply to arbitration.
Should every time there's an arbitration clause in a contract, should it also include a jury waiver?
No, it does not have to. But in this case, Judge, Your Honor, in this case it should have, because it is so unclear whether or not there is an agreement to arbitrate between my client and Mr. Linder. As the court knows, you have to look at the entire agreement. If you read the entire agreement, the bargain option agreement, at best it is unclear. If you look at page 1, it's an agreement between the two parties. It is not an agreement among parties. It is an agreement between two parties, the seller and the buyer. The seller is a defined term. The buyer is a defined term. Those are the parties to this agreement. If you go on further and if you look through the option agreement, the remedies are specifically between buyer and seller, not between buyer, seller, and principal. If you go to the indemnification provision, the indemnification is between the buyer and the seller, not with the principal.
Well, what was your client agreeing to, if anything? Why did they sign this agreement? They're not agreeing to anything, just sign for what?
This agreement is that there are ancillary agreements to this option agreement. The ancillary agreement is a note and mortgage.
And 12.20 is a provision that's part of this agreement that your client signed as to arbitration.
No, our client agreed to execute a note and a mortgage, which note and mortgage have specific remedies and rights, different from what is in this option agreement.
You're basically asking, it seems to me that your argument and perhaps Mr. Huber's argument is that our only obligations were to guarantee the $500,000, right? And that, if that needed to be paid, and since that wasn't necessary, the claims with respect to water rights have nothing to do with us. It only has something to do with the Huis,
Yes.
right?
Yes.
So you're basically asking this court to grant summary judgment that this has nothing to do with the water rights, that your clients have nothing to do with the water rights.
That's correct.
And you're saying because your clients have nothing to do with the water rights, they're not subject to the claim here is not subject to arbitration as to them, and they only signed with respect to the $500,000 that was
That's correct, Your Honor.
lent.
Well, let me ask this then. What do you think your client is entitled to a jury trial on? That's your argument. She's entitled to a jury trial on what issue? To determine what her rights or obligations are under the option agreement?
No, pursuant to the note and the mortgage, if there was a claim against them on the note and mortgage and a claim for damages, she would be entitled to a jury trial.
So then you are asking us to essentially decipher what are her rights and obligations under the option agreement at this stage, as opposed, so that if we do decide it is just as to the rights and as to the notes and mortgage, go to a jury trial. If it's as to the water issues, then your client has no
That's correct, Your Honor.
obligation.
That's correct. We have no obligation to arbitrate.
Which is why you take a different stand as to whether a jury trial is required, because I think some of the other parties sitting on that side of the bar with you, their argument is that it should go to the circuit court without a jury under 664-3233.
Well, they are different parties.
Right.
My client is Candace Strong.
You are simply asking for
Yes.
the waiver as to jury wasn't expressly made by her in this case.
Right. My client did not waive, knowingly and clearly waived the right to a jury trial in this case.
Thank you.
Mr. Wong, the agreement says, and this is on page 2, that the seller and principals intend to consolidate the ag lots pursuant to the ag ordinance and subdivide them in a certain way so as to create a separate lot. Doesn't that imply some ongoing involvement by your client?
It may, but it's an intent, Your Honor. There's no obligation for them to do that, and there's no dispute. There's no dispute. There would not be a claim against my client if they did not intend to do it or they didn't do it. The only obligation for my clients would be to pay on the promissory note and pay on the foreclosure. If there was a foreclosure lawsuit, then clearly they could not demand arbitration under foreclosure lawsuit as well. So
Very well.
we're stuck with that, Judge.
Very well. Thank you for your argument. I'll give you a little bit of time in rebuttal. We're
Thank you.
well over, but we'll give you some rebuttal time. All right, Mr. Irons.
Good morning, Chief Justice and Justices. May it please the court. I'm going to tackle these issues, sort of the last one, and move back. So I'll go address the last arguments and go back to the first arguments. Candace Strong and Paul Huber both signed as individuals and officers of the developer Moloaa Hui Lands, Inc.
The agreement says it's between buyer and seller, though, right?
So the agreement, in the first part of it, says the parties agree, and then it lists, after the recitals, all of the terms of the agreement. Parties is not defined in the body, but if you go to the signature page, it indicates that the parties are the individuals and the officers signing. So all the people on the last page of the agreement are the parties of the agreement. And both Ms. Strong and Paul Huber and Mike Strong, who's deceased, they were the makers on the note. attach this agreement. If their only obligation was to fulfill some duties to pay back the note, then there was no reason for them to be on this agreement as parties. So they were already covered. The reason why they were on the option was because Mr. Lindner was providing water to the entire development from the state well, which is not his water, it's the state's water. He just conveys it down to the system that was in place on the Moloaa lands. And that entire system was built by the Lihue plantation many, many years ago. So both of these individuals were parties to the option agreement. They both agreed to arbitrate under the AAA commercial rules. The agreement itself has a provision that it's not to be interpreted against either party, so that's not an issue. It's just you agreed to arbitrate. Regardless of the validity of the claims, that's for the arbitrator to decide. And this option provided not only the purchase of Lot 2, but it also provided for the development and entitlement of 15 units and the access to the water rights that previously existed. And so that March 13...
Under which provision? Under which provision was the water rights? Are you citing
So I do want to clarify...
the provision that I cited earlier?
I do want to clarify. I don't believe this is a case technically about water rights. This is not riparian or those type of rights. This is the facilities to convey the rights. So it's not the source, it's the conveyance. And at the time, when the March 13, 1997 declaration was recorded against all the land, lots 1 and 2, the declaration set forth in...
Can we go back to the option agreement? What portion of the option agreement are you saying conveyed some sort of water rights?
So it was understood through the definition in the beginning. I think you referred to it earlier in the recitals that the seller would convey all of their rights, including water rights. Technically, I think it's conveying the right to access the water. And just to clarify, the ag park that was in existence prior to the purchase, the consolidation, and re-subdivision into 2 lots did cover, the ag leases themselves covered portions of Lot 2. So they would have had access to that existing water system from the Lihue plantation. And it was carved out, and obviously this is all ag land, so all of the property needs access to water for farming because you're not allowed to have a dwelling unless it's ancillary to your agricultural farm. It's not a type 1 use, it's a secondary use to have a farm dwelling. And so at the time that the declaration was put in place, there were rights on Lot 2 to the water system. And then the declaration clarified on, this is record of appeal, or the supplemental record on appeal, the docket 2, but page 58, so it's section 4 of the declaration titled Water System. It says the existing water system for the project will continue to be used as long as it is available. And there's additional language before it that obviously clarifies that, well, if we lose the source, we're not guaranteeing you the right to water, but we are guaranteeing you the right to use the system if you own land in this project, which included Lot 2.
How do you respond to Mr. Tsukazaki's representation that your client actually has a different water source?
My client has the property on the Mauka side of Kahalui Highway, That's where, up on the hillside, the state well was that he drew water from, pumped through his property down to the Lot 1 property, or the Moloaa lands, where the water tank is located. And that well has now, the revocable permit for that well is now terminated. However, he has water on his own property, but he doesn't have the conveyance facilities to send it to Lot 2. He would be required to send it through the water tank, so the water would go to the tank that's on Lot 1 and then go through lines.
So your client does need to use the tank?
Yeah, absolutely. And it's not just for the water for farming and for potable use, it's also for fire pressure. That tank provides the fire pressure needed.
Didn't at one time they invite your client to join in with them and share the expenses and the development, and he declined?
No, their position. So let me kind of back up. So when Moloaa Lands Inc., the developer, which was Paul Huber, Candace Strong, Mike Strong, when that was originally created, the developer, Moloaa Inc., owned the unit underlying the water tank. That entity was administratively dissolved in 2008. At that point, the remaining officers and directors were Paul Huber and Candace Strong. They had a duty to wind that company down and notify creditors, but they didn't do anything. And instead, many years later, Candace Strong's son, who happens to be an attorney, Eric Strong, created a new entity that happened to have the exact same name as Moloaa Lands entity, and then conveyed the unit underneath the water tank to the Moloaa Irrigation Cooperative, which that's one of our issues is they've basically conveyed the unit underneath the tank to this new entity, which has no obligations to us. And I do want to make clear, the Moloaa Irrigation Cooperative does not own the system. The system is owned by the landowners. So that's the AOAOs and our position, Lot 2. So it's the owners of Lot 1 and Lot 2 own the system. The cooperative just manages it. And when
they're disputing your client's ownership of that.
They're disputing our ownership, and when they took over, we went to mediation, we tried to resolve it, and making these arguments that we, from this past declaration, have this right to access it just like all the other landowners. And they said, no, we're going to charge you $707,000 to hook up, and we're going to charge you considerably more than all the other users. And that's what triggered us filing the demand for arbitration.
You know, I thought I saw at one time, was there an agreement to submit the matter of arbitration to DPR?
Well, when we originally filed the demand, I did contact, or Paul Huber.
I'm just asking, was there an agreement at some point?
Between, yes, for at least one of the individuals.
And what was DPR's rules as far as arbitrability? Is that reserved to the arbitrator, or is that for the court?
I don't think it is, but that he rescinded his agreement to go to DPR when they filed and then they filed the motions to vacate arbitration.
But do you remember what the rule is with DPR arbitrability?
I'm not sure. I actually don't think they have the arbitrator do arbitrability. But
Mr. Irons, so what's your response to Mr. Osaki's argument that the declaration is irrelevant to determining his client's rights and responsibilities in this matter? It wasn't a signatory, so the provision you just invoked as creating rights for your client is not relevant to Huber or Strong.
I would say it's relevant in the sense that Huber and Strong were the developers that wrote that declaration. So they're the declarants. They took over numerous units within Lot 1 because they purchased it and kept many of the units for themselves after they created these two condominiums on this one lot. And so they are bound as owners and are subsequent purchasers of units within Lot 1 to these provisions. So I do think there is an obligation for them to arbitrate this dispute. Paul Huber is also the president of one of the associations. He also helped form the Moloaa Irrigation Cooperative, and was involved in many of the negotiations and basically the positions taken by the other side. And like I said, Ms. Strong, not only one of the declarants, also unit owner, has multiple units, and then basically conveyed a significant amount of control that should have stayed with the association to this Moloaa Irrigation Cooperative when they conveyed. Our position, it was illegal to the cooperative because they just recreated an LLC that had the same name, but they never met all the requirements for dissolution when it was administratively dissolved in 2008.
Mr. Irons, I have a question with regards to your demand for arbitration, wherein the second paragraph, I guess the allegation is that respondents negligently, grossly failed to provide access to and use of Moloaa Hui Land's water system. And I know we've had lots of discussion about what that, I guess, the water tanks and everything. I just want to understand from the purposes of the allegations in this demand, what is your definition of the water system?
So the water system would be the water tank, all of the water lines connected up to it, the pumps that it uses, the desalinators, the treatment facilities, anything that's connected that begins. Well, there's a dispute as to who actually owns the lines going into the tank, because they're all part of one system. And when my client kept the Mauka side, there's lines coming down that go connect into that water tank, and there's a dispute exactly where our rights end and theirs begin. However, at least from the water tank spreading out to all the different units, that is the system. And I would argue that if the AOAOs and the owners of Lot 2 are developing the system and making some repairs or changing out some lines, that's not a new system. And that was one of the things I noticed in the summary on the courts for this oral argument, that it said that we were trying to get access to a new system created by the Moloaa Irrigation Cooperative, and it is not a new system. It's the old existing system that just needed significant repairs.
Okay, and the water system, as alleged in your arbitration demand, is on what properties specifically?
So the water system is on all of the unit, or it depends where the lines exactly go, but the system was used to serve the ag land that was out there. Part of that ag land is on Lot 2. So is there a line out there, like a actual physical line?
Yes.
I can't say, but it was those. So the ag subdivision had plots that were leased, and if you go through all the meets and bounds of the plots that were leased, a good portion of the ones that are on the Mackay side bleed into Lot 2. So there's a whole strip along Lot 2 that was ag lands that were being leased, being served by this system.
And the source of the water, I think you've mentioned, is from the Lihui plantation system. Is that a system?
So up until, I guess, I don't know exactly, I think it was November maybe this year, all the water that served the Moloaa Hui farmers on Lot 1 came from the state well that went through my client's property. And now, I'm not, they may be pumping water at this point.
Part of this line of questioning for me is the argument from Mr. Sukazaki for sure is that the circuit court has exclusive jurisdiction to decide issues with regards to water rights. And so I'd like to understand as clear as possible from you why you believe that's incorrect.
Yeah, so 2 points. One, as I noted, I don't think this is a private water rights dispute. It's about infrastructure. So regardless of where the source of the water is, it's about access to the facilities necessary to convey the water. Like any condominium, you're going to have like common elements, and technically this is a bit different than a normal common element because it was a common facility created prior to the two land condominiums that were created on Lot 1.
So none of your issues raised in your arbitration demand go to the source of the water?
No.
Whatever water goes to the system,
Right.
Your argument is you should have an opportunity to fair utilization at similar costs.
Correct, fair access.
Fair access.
As to all the other landowners in the system. And then the second point I would make, I think that the ICA made as well, is that the water rights statute, which really hasn't been used, I think, since the water code was adopted, saying all water is owned by the state, but I read it as a permissive statute, not as a mandatory requirement that those disputes go to the court.
All right, thank you.
Can I come back to Huber and Strong? So I'm trying to understand why, in your view, they have agreed to arbitrate this dispute. If they're not signatories to the declaration, and there are other than, is your argument based entirely on this provision that says the real property that's being in the bargain purchase agreement that refers to all right, title, and interest, including water? That's the basis. Why are they here, or why would they be required to arbitrate?
Right. That's in part
Okay.
why. And then just from a technical standpoint,
Yeah.
as I noted, the parties agree as follows, and then have all the provisions, and at the end, they're defined as the parties. Now, specifically, I think you're asking, like, what actions or have they taken that would trigger this? And our position is that the provisions that require the seller, which is really them because they control the seller, and especially after it dissolved in 2008, to at all times, all relevant times, to make good faith efforts to provide Lot 2 with the 15-unit density, that is the breach. They're breaching.
To provide Lot 2 with to create or to support the create. You're talking about the purchase agreement now, correct?
I'm talking about the option.
The option part.
And I'm looking at, so
paragraph F. I'm just trying to understand what is it that they agreed to do that's implicated in this dispute, and where do they agree to arbitrate their alleged failure to live up to those obligations?
Right, so in section 11.7
Okay.
of the option, that's, I think, page 82 of,
Got it. I got it in front of me.
I think, second to last or third to last sentence, at all times relevant hereto, seller shall continue to make its best good faith efforts to create new parcel 1 as a legal lot or CPR as provided herein. And as provided herein, I would go back to section 11.1, that they are to provide a separate parcel with a residential farm dwelling density of 15 units in the general configuration shown on Exhibit A. So it's a promise to provide or entitle the land to have 15 dwelling units. And the fact that they gave up the land underneath the water tank to this cooperative, and then through this improper conveyance, and then tried to charge us to access the system, knowing that we have to have the water to entitle any development on that property we don't have the water, both fire and potable, we can't develop the property. And there's one other point that's also.
Who's on the other side for you? Corporations or them as individual? It's a corporations or corporations, right?
It doesn't exist as of 2008. It
Okay.
administratively dissolved. They're the ones, the directors that would have stepped in. And I think I made the point in the briefing that if you don't hold them just to the plain meaning of this document, that they're signing as parties and there's an arbitration provision, well, they could be charged as alter egos or as successors in interest to these obligations. And
what are you seeking with regard to them? An order? Why are they here? Why not just the corporate entities?
well, and partly, as I noted, they are owners, but what they're here for is frankly damages.
Okay, thank you.
In your demand, you allege breach of implied covenant of good faith and fair dealing, as well as gross negligence and or fraud, and you seek damages, including, so you're alleging that as principals, you're alleging potentially, as you said, ultravirus or lack of good faith in terms of.
Right, and their role after the entity itself dissolved and they became the directors and officers that were required to wind up the corporation. But there is one more point that was in the demand, which is that when Lot 2 went to subdivide before the county of Kauai, the county took the position that Lot 2 had to get the consent of Lot 1 to even process the subdivision application. So the county's position was effectively that we didn't actually have a separate independent legal lot. And that's another claim that we have in there, that was grossly negligent, that breached the agreement. You didn't give us a separate parcel that.
It wasn't subdivided?
It was subdivided, but so the county has a one-time subdivision ordinance that says anytime after 1972, you can only subdivide the large land acreages one time. And so what their original position was, well, we allowed you to consolidate and subdivide into these two units, but if you try and subdivide it again, we're treating it as all one unit. And so they were saying you had to get the consent from all the Lot 1 owners in order to subdivide, because they were figuring out density not based on these two new lots. They were figuring out density based on the pre-existing land, which was a big lot that had an ag subdivision on it, but an ag subdivision is not it's a different type of subdivision. It's based on leases. You don't actually have separate sort of fee title to the land.
Can I come back? I'm sorry to keep harping on Huber and Strong, but I'm looking at the provisions that you referred me to earlier, 11.1, 11.7. They talk about the seller as opposed to the seller and the principals. And Huber and Strong were defined as being principals. So again, why are they here as individuals if those particular provisions don't relate to them as principals?
I just have to reiterate that when the entity dissolved, they step into the shoes of the entity that they were in charge of.
And that binds them to the arbitration agreement as a successor in interest? I'm just asking.
I understand, and I think these are, I think they're more valid arguments that could be made in the arbitration. I don't think they go to the two-step of, is there a valid agreement? I think under HSTA, there's clearly, both of these agreements are in writing. They clearly send the disputes to AAA commercial rules. And they both have consideration. The option, because you're getting money for development purposes, and the declarations, you get the benefits of covenants and conditions on the land. So I think they're clearly valid agreements. And then the arbitrability of it, we agree with the ICA that all of the federal authority that has addressed this issue, I think with the only exception of class action arbitrations, all of it says if you adopt the AAA commercial rules, you have unmistakably given arbitrability to the arbitrator. So I think some of these issues are interesting for the arbitrator, but on a technical level, the agreement exists, they're parties to the agreement, they're bound by the agreement. My client is entitled to and has the right to what was bargained for. And, you know, I would say even if the court disagrees with the federal authority, there's significant facts that show that the underlying claims we are raising are disputes as to the meaning and terms of both of these agreements. So I think
your answer to me is take it to the arbitrator, basically.
Yeah, and I think a lot of these issues, some I believe probably do have some merit and some don't, but it's for the arbitrator to decide.
Very well. Anything further at this point?
Unless there's any further questions. Thank you, Your Honor.
All right, thank you. Thank you, Mr. Irons. All right, Mr. Sukazaki, we went over, but I'll give you a couple minutes to share your thoughts. But do keep it brief.
Try to keep it brief. I want to address 2 points very quickly. Hawaii State Teachers Association, this court's precedent, clear and unmistakable reservation, unambiguous intent to submit a dispute to arbitration. If there is any doubt whatsoever, then you have to recognize the circuit court's jurisdiction to decide whether or not the claims are arbitrable or not. Justice Devin said at a point about whether or not if you actually attach the rules, the arbitration rules from AAA, would that make a difference? In this case, we know that did not happen. And when you look at the specific language, both in the option agreement and in the declaration, they both reference first having an existing arbitration to which you would apply the rules. But it doesn't say anything more than that. It doesn't say anything else that you can say it was clear and unmistakable reservation of arbitrability to the arbitrator. And when you look at Rule R7, that also just generally references the general power of the arbitrator. Again, it doesn't say that if there's a dispute, he has to decide it, or that he trumps the circuit court's jurisdiction under the statutes. The last point is about the water rights and the questions about water rights. As Mr. Irons has explained, as he's explained it, it's exactly that case that is before the circuit court to decide how to regulate the use, the cost, the infrastructure, the delivery, transportation.
Does the statute trump the Constitution's Water Commission, creation of the Water Commission?
No, but let me explain. Under the Constitution, the state of Hawaii is to protect, conserve, and regulate its water resources, right? The water rights law has been on the books in Hawaii since 1860 under King Kamehameha IV. Over the last 60 years, it's only defined 4 terms, and only recently 2. It defined the commissioners, it defined courts, it defined controversies, it defined parties, it defined private individuals. 66431 only defines 2 words, controversy and private individuals or parties and persons. That's the only 2 definitions. In the 160 years of the law being on the books, it never defined water rights and what that meant. Given the Constitution's public policy to protect, conserve, regulate water, given 664-33 and 34, expressly saying the circuit courts shall determine all controversies respecting rights of private way and water rights. The fact that over 160 years, water rights was never defined, and given the public policy, it was intended to give the circuit courts the jurisdiction and the broad jurisdiction to decide if that's the case. It needs to decide to protect water rights. Who's going to protect that for Kauai, for this community? If you're in an arbitration, they don't have the same protections as 664-34.
Are the amounts of water at stake? Obviously, given the addition of another group of users.
I have to believe it is significant. We're talking about lots that are the farming community in this area. We're talking about at least 15 that they can develop, up to 15 residential homes in the lot 2. Now, I have questions about, and yes, it would probably be subject to motions for summary judgment about whether or not they have any rights to water, given that the declarant, the developer, expressly says he makes no guarantees or warranties about water. So that's a separate issue. But in this particular case, the question about the water rights, delivery, transportation, the comment about the demand for $700,000 when my clients offered them the opportunity, Mr. Linda, opportunity to participate, that was for infrastructure. That was for connecting pipes that would go to Lot 2, because Lot 2 was always a separate deal. That's the excluded lands. So who's going to decide this? Who's going to protect it? If it gets decided in arbitration, we're never back here before this court or any appellate court in Hawaii to decide if that was right or wrong.
Mr. Sukazaki, if you could wrap up your argument. I think we understand that point.
Thank you, Your Honor. I think the last point I will want to make is what's getting lost in all of this is who are the parties? The associations were never created at the time this 1997 declaration was recorded. It was basically the developer's intent of what he was going to do with this project in creating excluded lands and doing CPRs for developing these associations. The associations were not around. There was no consideration in that aspect of it. This was not a bargain for agreement where you can say that we agreed that the AAA rules would apply and that we would understand that the arbitrability issue would go to the arbitrator. None of that exists.
Very well. Thank you for your argument. Mr. Osaki, brief rebuttal.
Thank you. I'll make 2 points. I think as far as Mr. Huber as an individual is concerned, the focus has to remain on why he signed the option and what did he agree to arbitrate under the option. And when you say, why did he sign the option? It was contingent. It was multiple contingencies that never happened. And what did he agree to arbitrate? That's why I spent a fair amount of time in the writ discussing the meaning of here under. What is that meaning? And why is that a limitation on what can be arbitrated? And it is important in this world that we live in now, especially with the internet, and especially with companies that are trying to create expansive forever arbitration clauses that cover everything. I think I cited them in footnote 3 on page 11, the Walt Disney World case, the Uber Eats case. And what this kind of language does in this particular arbitration agreement is put a limit on it. It's very clear that what you agree to arbitrate are those disputes that arise here under the option agreement. And in this case, those possibilities disappeared in 1998 when Mr. Linder exercised his option to buy, thus obviating Mr. Huber and Ms. Strong's involvement. Thank you.
Very well, thank you. Mr. Wong?
Very quickly, Your Honors. My point, to reiterate my point, Your Honor, which is made more important by Mr. Appellant's argument that they're claiming damages, is that, you know, we didn't waive our right to a jury trial. I think it's clear. I think if you look at the agreement, they basically conflate seller and the principals. And they ignore all the other portions of the agreement, which clearly denotes seller and buyer, seller and buyer. We cannot, we or no one else, whether you, me, or I, cannot waive our right to a jury trial unless they show that clearly and unequivocally, and we did not. Ms. Strong did not, as well as Mr. Huber. Thank you, Your Honor.
Thank you, Mr. Wong. Thank you to all of our counsel for your arguments today. The court will take this matter under advisement.
E ku iluna, please rise. Ua ho'o malolo ia mai ne kea aha ho'o kolo ki hana. This Honorable Supreme Court is now recessed.